Hello, friends. Today we're going to discuss what a court may consider to be a marital asset during a divorce proceeding. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. Now, before I even get started, I have to give you a disclosure. Each state and jurisdiction is different. So what a court in Florida may consider as a marital asset in a divorce proceeding may be completely different, for example, as to what a court in my home state of Illinois or California or Texas may consider as a marital asset in a divorce proceeding. Now, turning our eyes back to the Sunshine State of Florida. In Florida, courts are governed by Florida Statute 61.075 when determining what marital assets are in a divorce proceeding. The statute breaks down certain categories of what a marital asset is, and we'll try to describe them and explain them here. First, the statute says that any assets acquired during the marriage, either individually or jointly by the spouses, is considered marital. What are some examples of these types of assets that are acquired either individually or jointly by spouses during the marriage? Well, the obvious one is the marital home. If the home is acquired during the marriage, it is a marital asset. This also could include rental properties. So if you have a vacation home, or a rental property or an Airbnb that was acquired during the marriage, Florida courts seem to indicate that that is marital. Also, furniture, artwork, jewelry, collectibles, any of those items bought during the marriage seems to be marital. Your car, your boat, your motorcycle, things of that nature are considered to be marital assets as well if they are purchased during the marriage. One of the surprise items when I speak with clients is salaries. Any salary that you earn during the marriage is marital, and that will come into play in a little bit later. Salaries also include bonuses, so bonus money is marital. I tell some clients about this and their eyes get really large and they're a little bit surprised. In addition to this, any partnership interest or businesses that are acquired during the marriage are marital. And also, bank accounts. Any bank accounts acquired during the marriage are marital, as well as any type of brokerage accounts. For those of you who are inventors, if you invent a special patent or special invention during the course of the marriage, it is considered marital in Florida. And for all of you celebrities, songwriters, artists, any type of songbook or royalties earned during the course of the intact marriage are considered marital under the Florida statute. So be aware. The second category of items which Florida may consider to be marital assets are the enhancement in value and appreciation of non-marital assets resulting from the efforts of either party during the marriage or the expenditure of marital funds or other forms of marital assets or both to enhance that non-marital property. What does that mean? That means essentially, to summarize, if a non-marital property is enhanced either through the efforts of either party during the marriage, or if marital funds, for example, a salary or a joint account, is used to enhance that non-marital asset, then that non-marital asset could become partially or entirely a marital asset. In the business, they call that commingling, when you commingle marital funds into a non-marital asset. Let me give you a couple of examples to think about and contemplate. The first example are bank accounts. If one of the spouses has a non-marital bank account that was there before the marriage, and then the parties during the course of the marriage start putting in marital funds into that non-marital bank account, then that non-marital bank account starts to become and may become marital. That is because money is fungible and you cannot tell which dollar bill is the marital one and which one is the non-marital one. So it all becomes a marital property. Another example is if a spouse comes into a marriage with a non-marital property. Let's say they have a rental property. Let's say they sell that rental property that was non-marital and they put it into a joint bank account with the spouse. That money from the non-marital property may become marital funds because now it is commingled into a marital account. Also, the one that is always the biggest fight is a non-marital business. Let's say that one of the spouses owned a business before they got married. Subsequent to the marriage, the other spouse starts to work at that business, or perhaps they contributed some sort of cash influx to help the business out. Then there's an argument that there has been some commingling of marital funds in that non-marital business, and there may be a marital component of that business. The third category of what the Florida statute indicates is a marital asset is the pay down of principal of a note and mortgage secured by a non-marital real property and a portion of any passive appreciation in that property. The seminal case was the Supreme Court case Ka versus Ka. It was decided by the Supreme Court of Florida in 2010. That couple, they were married for 27 years. The husband purchased a non-marital property about 6 months before their marriage. The wife's name was never placed on the deed, despite the fact that the parties refinanced the mortgage. They made several improvements, including the carport, and the mortgage on the marital home was paid by marital funds, which presumably were the salary of Mr. Ka. When the parties got divorced, the property was significantly higher in value. Mr. Ka said that the wife was not entitled to the passive appreciation. The Supreme Court decided that they disagreed with Mr. Ka and said that the wife was entitled to the passive appreciation of that non-marital property. The Supreme Court then set up a 5-step factors as to how to determine what part of passive appreciation is a marital asset when it comes to non-marital properties. That was the rule of law in Florida from about 2010 to 2018. Effective July 1st of 2018, the legislature amended Florida Statute 61.075, subsection 6, and it described in detail the coverture factor, which is the way that the passive appreciation is now addressed in Florida. It's now, instead of a 5-step approach, it's a 3-step approach where they determine the amount of the passive appreciation, the percentage of the passive appreciation, and then the amount of the marital appreciation based on the formula in that statute. We're not going to do any more on this video to try to figure out how to calculate that coverture fracture. And remember, this is Florida. Each state is different. I don't know if they have a coverture fracture in other states, but if they do, look online to see how you can figure out how to determine passive appreciation of non-marital properties. Next is the fourth category of assets considered to be marital in Florida, and that would be interspousal gifts during the marriage. Pro tip, a lot of people ask me about the engagement ring. Well, the engagement ring is out. That's right. That is a conditional gift that belongs to the person that received it once the parties are married. What I am talking about is when the gifts that one spouse gives to the other during the intact marriage. Think holiday, anniversary, and birthday gifts. And now the final and fifth category under Florida statute, it would be the vested as well as the non-vested benefits, rights, and funds accrued during the marriage in retirement, pension, profit sharing, annuity, deferred compensation, insurance plans, and programs like that. The big one is pensions. That's right, for all of you who are police officers, firefighters, work for the government, are educators, teachers, or in a union, your pension during the course of the marriage may have a marital component, as well as the defined contribution plans like the 401ks, the 403bs, the IRAs, as well as the thrift savings plans, and also life insurance policies. And we're usually talking about the whole life insurance policies, the ones that have a cash surrender value. And that is the breakdown on what Florida courts consider to be assets in a divorce proceeding. I cannot say it enough. Please remember that each case is different. Each state and jurisdiction has different laws, so please look up the statute of your particular jurisdiction to see what courts may consider to be a marital asset. Remember that we have offices in Miami and Orlando, Florida. Se habla español. You can look us up at www.segarralawfirm.com. Please do us a favor and like this video, subscribe to the Divorce Broadcast, and please share this video with anyone that's trying to determine if a particular asset is marital in a divorce. Thank you.